This is the Asset Protection Show. Expert strategies by attorney John Skabelund.
Welcome to the Asset Protection Show, the podcast dedicated to not only protecting your assets from lawsuits and creditors, but also protecting your legacy. After all, what we do isn't just for ourselves, but to create generational wealth. I'm your host, John Skabelund. Today will be the fourth and final installment on our series about LLCs and the most common questions I receive from real estate investors who want to upgrade their wealth and safeguard their assets. If you haven't checked out the prior 3 episodes where I answered common questions from real estate investors, I encourage you to do so. So today's first question will be, can I create an LLC at any time? Or put a different way, is it ever too late to create the LLC? Well, the question becomes all about liability. Has there been an event that would create a lawsuit? In other words, if you have a rental property already in your name and someone has already been injured on your property, it's too late to protect you from that particular event. Can we still protect the property from future events? Absolutely. But what you need to understand is a concept called fraudulent transfer. If we help you transfer your assets in a way where your plaintiff cannot reach them, that is a felony. And it's not only a felony for you, but it could be a felony for us as well. So every client that we meet with, we're always asking, are you involved in a lawsuit? Are you aware of a pending potential lawsuit? Has there ever been an accident within the statute of limitations that could cause a lawsuit? So the answer is, can you create an LLC anytime? Yes, you can, provided that there isn't a lawsuit already commencing or potential of a lawsuit. I often get asked, well, I've already purchased the property. Can I then create an LLC and move that property into the LLC? Absolutely. There's no reason to take unnecessary risk. Just because you've already purchased the property doesn't mean that you're not able to fix your mistake and move it into an LLC. Now, I will tell you the downside of not having the LLC created prior to purchasing is really a lack of privacy, first and foremost. The concern is that there will be a recording of the deed where you've transferred it from you to the LLC. Now, to the outside world, it may look like you sold the property to an investment company, and that's okay. But just realize that ideally, when you are purchasing the property into an LLC, assuming the financing is arranged to enable you to do so, then it provides that privacy that we also like, because that deed never shows up where you transferred it into the LLC. Also recognize that there are other issues when you transfer the property into an LLC, such as title insurance, property insurance, and the lease agreements. So all those need to be updated once you've transferred the property into an LLC. Second question we're going to talk about today is, do I need anything more than an LLC? In other words, there are many tools available to us as asset protection attorneys that specialize in this area. Very common tools that we like to use are irrevocable trusts, such as Asset Protection Trust or Cook Islands Trust. Limited partnerships are amazing, and we strongly recommend those, but we always want to right-size your plan with the assets or exposure that you have and your risk tolerance, frankly. So it isn't uncommon for those that are starting out in real estate investing that will only do LLCs, but then we'll introduce and implement a limited partnership, and then eventually also implement a Cook Islands Trust or Asset Protection Trust. Again, why not Asset Protection Trust right from the get-go? Just realize that Asset Protection Trusts, they are helpful, but they have their purpose. They're very effective for liquid assets, such as brokerage accounts and bank accounts. But you need to always remember that the situs of the property, meaning where the property is located, is where the judge is going to be applying the law. So if you have a foreign asset protection trust, Cook Islands Trust, owning this particular property, well, the judge in your local state is not going to give much credence to that because your local state's laws and rules will apply to it. Now, that begs the question, why do you want a foreign asset protection trust or a Cook Islands trust? The idea is that we're able to siphon off the rental income and the cash flow from that property offshore to another jurisdiction. And that's the real benefit. You can also refinance the property, moving some of that equity offshore as well. But I don't want everyone to think that fool's gold is applicable here. You always want to have the property in an LLC where the property is actually located, but layered above it is always a real estate holding company, and then we will have a limited partnership, and then that limited partnership is owned by a Cook Islands trust or asset protection trust. A domestic asset protection trust is helpful, but not the end-all be-all. And again, there's a time and place for everything in this, but having a property directly owned by a domestic asset protection trust is not the answer. Parallel to that is often an irrevocable trust. Why don't we just put every property inside an irrevocable trust? Well, there's some considerations there that you probably don't recognize. One is taxation of that irrevocable trust. Irrevocable trusts are taxed at the highest tax rate. So although your tax bracket might be lower, it does not matter because your rental income property is now being taxed at a trust rate because it's owned by an irrevocable trust. Second, recognize that irrevocable trusts are not very flexible, meaning when they're inside an LLC, there's a lot of flexibility as far as the sale, use, maintenance, and taxation of that particular property. A lot of that flexibility is gone if we're putting it inside an irrevocable trust. So ordinarily, we do not recommend that a rental property be in an irrevocable trust. You may also be wondering, what about a land trust? Well, a land trust can be irrevocable, which we don't recommend, or it can be revocable. But the problem with a land trust is it does not provide asset protection. It provides privacy. And frankly, that privacy can be established through LLCs when properly done. Again, that is why we love Wyoming LLCs as a holding company. So we can create the same privacy that a land trust can create, but in a more efficient, elegant manner than a land trust. And again, the land trust is not providing you asset protection. That is a big misnomer about land trusts. And in case you're wondering, why do we love limited partnerships? Well, limited partnerships often are the heart of your plan when you're ready for it. Limited partnerships offer great flexibility, and it's a holding company of all your other holding companies themselves. And so it offers greater asset protection because limited partnerships can only be created in one way, unlike LLCs. LLCs, I like to compare to ice cream. Listeners, if I ask you to think of ice cream, you might be thinking of mint chip or your favorite cookie dough or vanilla. If I ask you to think of creme brulee, though, we are all thinking of the same thing because you can only create creme brulee in one way. Well, remember, in litigation, we want certainty, and limited partnerships provide us that certainty. There's only one way to create them. There's always a general partner. The general partner is the one that has all the risk associated. If there's ever a lawsuit, the general partner is getting sued. And again, we protect you from that general partnership. That's one of the big mistakes that I see many make whenever they're doing a limited partnership is they will have the general partnership interest in the client's name. That's foolish because you're exposing your client unnecessarily to lawsuits, and you're also exposing that general partnership interest to the client's lawsuits personally. But the other kind of partner is a limited partner. This is the passive investor. This party or person has no exposure to a lawsuit. And so it's very different from an LLC. They've also been around much longer. LLCs are relatively new. They've been only around for less than 50 years, whereas limited partnerships have been around for hundreds of years. They are tried and true in the courts. Judges like them because, again, there's only one way to create them, whereas with LLC, there's a myriad of ways to create them. The judge has to decipher through an operating agreement to see how this was particularly created. Is it manager managed, member managed? What kind of rules and machinations are inside this operating agreement? So we love limited partnerships, especially based here in Arizona. Arizona, I believe, is the best jurisdiction for limited partnerships, just like I believe Wyoming is the best jurisdiction for holding LLCs. So yes, limited partnerships are fantastic. They are more expensive to create than a LLC. So most of my clients aren't ready necessarily for a limited partnership when they begin investing, but we do like to add the limited partnership above the holding company in Wyoming whenever the client can afford to do so, or their risk tolerance really warrants that additional layer. The third question for today is, isn't insurance simply enough? Why don't we just get more insurance and not even bother with LLC? And sadly, I get this question a lot from advisors to the clients, whether it's from an uneducated tax advisor or financial advisor. The problem with insurance is, one, it's actually more expensive than just doing it right in an LLC, meaning we're going to be paying for excess insurance on an annual basis. And I can guarantee you that if we simply put the property inside an LLC, you will save more money within 5 years of time than you will in paying premium policies on insurance to cover that exact same risk. But newsflash, unfortunately, insurance is not applicable. And insurance companies love to deny claims, and there's often exemptions. If you ever are in doubt, read your insurance policy. There are so many exceptions to them where they are creating avenues to deny a claim. So unfortunately, insurance is not enough by itself because insurance may not cover the claim that we're trying to protect ourselves against. Whereas an LLC, without a doubt, will always limit that inside risk. This is the risk where if someone is injured on the property, they sue the owner of the property. And if that is you, client, everything you own is exposed to that lawsuit. Well, again, the advisor unknowingly may say, well, why don't we just get a large policy above this property? Well, one, we're assuming that the accident has not exceeded policy limits. Again, sadly, I've seen where people have died in rental properties, and it blows through the insurance. Secondly, we're also assuming that the insurance coverage is not going to be denied. But third, we're missing the point that we're protecting the client from accidents on the property. Well, what about vice versa, the outside risk? When a client is sued themselves due to a car accident or business dispute or something, don't forget that the LLC is actually protecting the rental property and all your equity from the client's personal lawsuits. So again, just having insurance, whether on an individual level or on the property itself, simply isn't enough. Also, don't forget about potential tax advantages here. So realize that when we have this property in an LLC, we're removing that Schedule E that might be showing up on your personal tax return, which is actually placing you at a higher risk of audit. And if you're audited, it's going to be a much more complex audit because now they're going to scrutinize the property and all of your business dealings with that particular property. Whereas if we have it in an LLC, that LLC is going to create a K1, not a Schedule E. That means that your risk of audit is actually lowered. And if there is an audit, it's going to be a simple audit rather than a complex audit where they're prying into all your properties. Furthermore, also remember that when it's inside an LLC, it's nice and clean. We'll have a separate bank account. We're able to take business deductions, and it's all contained within that LLC, and that LLC is K1. So there are other advantages to having your property in an LLC beyond just asset protection. The last question of our series will be, if LLCs are fantastic for investment properties, why don't I put my personal residence inside an LLC? Well, the reason is this. Unless you are renting your personal residence out, meaning you have an accessory dwelling unit or a casita, or maybe you have a basement that you're renting out, or perhaps while you're on vacation, you rent out your personal residence as an Airbnb, or you do house swapping or something like that. I don't recommend an LLC to own your personal residence because of the loss of tax benefits and the underlying business purpose that is needed. In regards to tax benefits, I'm worried about the capital gains exemption. Although there are exceptions, the general rule is that if you've lived in your primary residence 2 out of the last 5 years, you're able to exempt $250,000 of capital gains per person. So if you're married and it's jointly owned, that's $500,000 of capital gains on the sale of your property you're able to exempt if it's considered a primary residence. Well, the moment that you're transferring your property into an LLC, that clock is ticking. I tell my clients all the time, even when we are renting out the property, we need to revisit whether we want to resell this property within 3 years of transferring it into an LLC. Why 3 years? Again, we can take it back out of the LLC and make sure that it's still 2 out of the last 5 years, and we can sell the property and exempt $250,000 or $500,000 for a married couple on the sale of the property. So that tax exemption is gone when we're putting it into an LLC. Other considerations you need to be aware of is the business purpose. There needs to be a business purpose for every LLC. And so if you're not renting out your property, there needs to be a business purpose to the LLC. And when you move your primary residence into the LLC, you should be paying reasonable rent for the use of your property. What does that mean? Well, you might be paying your own LLC $3,000, $4,000, $5,000 in monthly rent. What are the tax impacts to that? Well, if it's flowing onto a partnership tax return, that means that income of $5,000 per month, $60,000 a year, is now flowing on to the 1065 tax return for the partnership holding company. And now you're paying tax on your own rent. And I'll be honest, most clients are not excited about writing a rent check to their own LLC. So there are many other options and tools available to protect your residence. My favorite is a qualified personal residence trust or stripping the equity below your homestead exemption if possible. Just know that those are better options than putting your personal residence in an LLC unless you are renting out your LLC. That is the exception. So if you're renting out your residence, I do recommend that it be in an LLC, even if all things being equal, a qualified personal residence trust or you're below the state homestead exemption would be applicable. Again, I want to contain your risk and liability of someone being injured on your property and suing you as the homeowner. Well, if we put that in an LLC, we're limiting that liability to only the LLC. So wrapping up the series, I hope that these questions and answers have been helpful to you in regards to LLCs. If you're just starting to invest in real estate, I often get asked, where should I begin? You start by having right advisors. You need a great tax advisor and you need an attorney that specializes in asset protection. Again, estate planning attorneys and business lawyers mean well, but unless they specialize in asset protection, they don't understand the complexity that is inherent in protecting you from your asset and your asset from your personal lawsuits. So it can be as simple as one LLC, and then we build from that foundation. However, typically, we do want to have a real estate holding company for privacy and an additional layer of protection. And again, Wyoming is my favorite state to do that. So begin with a correct foundation, a foundation that is not only strong from an asset protection standpoint, but also tax advantaged. Make sure that you're working with a strategic tax advisor, not just a tax preparer. And I will tease an upcoming real estate investor series that I'll be creating, which is recent mistakes that I've seen real estate investors make about asset protection. And with that, we'll wrap up today's episode. Thank you so much for joining me. My goal with this podcast is to give you great actionable content that empowers you to protect the assets you've worked so hard to build. To help me do that, I'd love to hear from you. What topics are on your mind? Are there specific strategies or legal questions you want me to cover? Please leave a comment and let me know. And if you found today's information valuable, please consider sharing this episode with someone who might also benefit. Word of mouth is a great way for this show to grow. Finally, if you have a moment, leaving a quick rating and review on your favorite podcast app would be a huge help. It only takes a minute, and it really makes a difference in helping others find the show so that they too can learn from an asset protection attorney about how to protect their assets and preserve their legacy. Thank you for listening. Until next time, stay protected.
You've been listening to the Asset Protection Show, expert strategies by attorney John Skabelund. For more information, go to assetprotectionshow.com.
This content is legal information only and not legal advice. Viewing this content does not create an attorney-client relationship. Mr. Skabelund is admitted to practice law in Arizona, and he may be reached at ultimateassetprotection.com.